There was so much anger towards Kouri from the family, which Laura said impacted her original opinions. Oh, did she change her mind? Interesting. It's Wednesday, it's March 18th, and boy, we have a lot to talk about. We had hoped that we would see a juror have something to say, and today is that day because a juror has spoken with ABC. We're going to talk about that. I said on verdict day we were going to look at some of the bond hearing that we had not seen in a number of years. So we're going to take a look at the bond hearing together. We're going to take a look at the verdict forms because I have those. We're going to take a look at sentencing because I have some modifications to make because my memory and reality are not the same. So there are some updates about sentencing that we need to talk about. Sentencing, verdict forms, juror speaks out, and, well, we need to take a look at that bond hearing in hindsight because I feel like we're going to learn a lot. Let's pull up the verdict form, shall we? This is the original verdict form. It is redacted, so none of the jurors' names are on it. Stamped March 17th, 2026. Verdict form. Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Kouri Richins, is not guilty of aggravated murder. Look at how easy that is. Inquiry 1A. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count 1 beyond a reasonable doubt. Check all apply. Your decision to check any circumstance must be unanimous. Is there any question about what you're being asked to do? Nope. They checked the homicide was committed for pecuniary gain. Must be the money. And 2, the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Very clear cut. And I think the attorneys covered it well. This is where the defense was arguing, it has to be fentanyl, it has to be fentanyl, it has to be fentanyl. And where the prosecution was saying, it has to be considered by her and actually be lethal. What she gives Eric Richins has to be in a lethal amount, dosage, or quantity. But it does not have to be a particular substance. Count 2, attempted aggravated murder. We, the jury, unanimously find that Kouri Richins is not guilty of attempted murder with guilty checked. Inquiry 2A. We, the jury, unanimously agree that the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt. Check all apply. Count 1. The attempted homicide was committed for pecuniary gain. Checked. 2, the attempted homicide was committed by means of administration of any substance administered in a lethal amount, dosage, or quantity. Not checked. You know why? Because it says lethal amount, dosage, or quantity, and he did not die. It's an attempted murder. Based on the language of this, I think the jury read that and went, all right. If not dead, then not lethal. Fair, because he survived. You can check one or both, but the jurors read this. The jurors paid attention to it. The jurors just didn't go through and go tick, 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 and check everything. And the prosecution didn't argue the puzzle pieces here and didn't argue that the attempt could be by poisoning if you didn't die. Because the language says in a lethal amount. It was a quick verdict, but it does not indicate to me that they did not pay attention and talk about this case. And this, again, the 2 different aggravators or special circumstances, I think the language of the special circumstance says it has to be administered in a lethal amount. And there's no argument here that that applies if somebody survives. And it wasn't addressed in closing arguments. I think attempted for pecuniary gain makes sense, but attempt and lethal are a mismatch, and I understand. All right, count 3. Insurance fraud, January 29th to August 1st. We, the jury, unanimously find that the defendant, Kouri Richins, and then it gives not guilty, guilty options, ticked guilty for insurance fraud. Count 4, insurance fraud, June 14th, 2022. Unanimously find Kouri Richins is guilty of insurance fraud. And then count 5, forgery. We, the jury, unanimously find that the defendant, Kouri Richins, is guilty of forgery, dated the 16th day of March, 2026. That's it, and signed. Love how simple the verdict forms are. This is why the jury instructions matter. The jury instructions need to explain what all of this means. The verdict forms should be this simple. Did the crime happen? Did the defendant do it? That's it. Let's take a look at sentencing, shall we? Because there is information that I had wrong, and so I want to correct the record on that. There's information that I'm sure you're going to see in articles and conversation that is wrong, and I want to correct that because I have now seen so many different recitations of the sentencing, and it is worth a conversation because on Monday I was like, oh, they didn't seek the death penalty. It's going to be LWOP. No, not necessarily. It can be LWOP, but it does not have to be. Emily, what is LWOP? LWOP is life without the possibility of parole. It does not have to be, which I was incorrect about. And I cannot make fetch happen on that. The judge actually has a choice between 25 to life or life without the possibility of parole. I have seen some people say it's 25 years. I've seen some people say it's 25 to life. I have seen some people, including myself, say it's life without parole. It could be either, which breaks my brain, but it could be either. Sentencing provision. First degree felony, aggravated murder, non-capital felony. Emily, why is this a non-capital felony? Because the prosecution chose not to seek the death penalty. This is a non-capital felony because the prosecution chose not to seek the death penalty in this case. So it is a non-capital felony. Were it a capital felony, they would have gotten 12 jurors. And the defense actually argued that this should get 12 jurors because it could be a capital felony. They could have filed to seek the death penalty. They chose not to. But it could have been. So the defense was like, but it could be a capital felony. We should have 12 jurors. And the court was like, the law is clear. If DP is not on the table, then you do not get 12 jurors. DP not on the table, no 12 jurors. First degree felony, aggravated murder, non-capital felony, penalties sentenced by the court. A person who has pled guilty or been convicted of a first degree aggravated murder, Kouri Richins, shall be sentenced by the court. The sentence under this section shall be either life in prison without parole or an indeterminate prison term of not less than 25 years, and that may be for life. So the floor on that is 25, and then it goes up. And then the up is determined by the Department of Prisons. So they can then determine whether she's eligible for parole down the road, and things like accepting responsibility and all of the things you can do in custody can play into that. That's up to the parole board. So she could either get life in prison without parole or 25 to life. The judge will get to choose. Now, I can see the prosecution arguing for 25 to life and then adding all of the other sentences. So it ends up being 25 plus, I think it's 15 on the attempt, but we'll go look at that in just a second. But 25 to life plus 15 would be 40. And then plus the fraud counts. I could see them arguing for either like almost 50 years. I don't know if they'll get up to that number, almost 50 years to life as a floor instead of LWOP, and saying it should be this or LWOP. And so I think we will see the prosecution arguing for that. I imagine we will see the victim's family asking the court for life without parole so that they do not have to worry about the potentiality of her getting out of custody one day and continuing to wreak havoc on their family. There is a DV aggravator which will add time. I do not know how much. We will see. There are multiple aggravators found here. I think there is an argument for life without parole. But I could also see the argument of, is she a danger to the broader community, or was she just a danger to those who trusted her the most? And there's an argument that, and I think the defense will probably argue, that this should be 25 to life. This makes a ton of sense why a pre-sentencing investigation will matter so much. A huge factor of pre-sentencing investigation is taking responsibility. Do you think that Kouri Richins will show remorse and take responsibility when she's interviewed between now and May? Yeah, me neither. All right, attempt. Classification of offenses. A violation of section 76-4-101, where the actor attempts to commit a capital felony. That's where we're at. We're in the realm of a capital felony. Because they found the aggravating circumstance of pecuniary gain, we are in the world of capital felony, or felony punishable by LWOP, is a first-degree felony. So it says, except as provided for in subsection 2. I don't think we're in subsection 2. I do not practice in Utah, but I do not think we're in subsection 2. Subsection 2 is an aggravated murder which results in serious bodily injury. Eric Richins, by all accounts, was ill and then still went and picked the kids up. So did not go to the hospital. There is argument here that the attempt did not result in serious bodily injury. I think you would be very hard pressed to argue that the attempt resulted in serious bodily injury. So serious bodily injury under the statutes and under the case law talks about physical bodily injury. So I don't think we are going to see the argument that this should be 15 years to life, because I do not think we are in the world of serious bodily injury. So I think we are just looking at a capital felony that's going to be punished as a first-degree felony. If we are looking at that, and if I am reading this correctly, it looks like we might be in the realm of 5 years to life for an attempt, which also breaks my brain that that's kind of where we are. But I think we are in the realm of an additional 5 years to life, which again seems really low to me on an attempted aggravated murder. It seems like we should be in the 15 years to life realm, but vibes is not what we do. I think we're probably in the 5 to life range, which would, if you stacked them, put her in the potential of 30 to life before we get to the fraud cases.
There was never a not guilty check with anything, with any element, nothing.
Here's why that's so interesting to me. Do you remember what the defense asked in their closing? The defense said, don't just go back and take a vote. Go back and look at where there is doubt. And this juror is like, nope, yeah, no, no.
Laura and her fellow jurors taking less than 3 hours to find Richins guilty on all 5 counts, including aggravated murder, insurance fraud, and forgery.
Even though
I just want to hear what the juror has to say, but it is interspliced. I do not think that creates an issue for appeal. They were convinced by the evidence. I do not think that creates an issue.
oh, it was just 3 hours, I felt like we came into that deliberation fully loaded to evaluate the case and to look at the evidence. We had to zoom in on these little bits of evidence and kind of ignore all the fluff and ignore the drama.
Laura says each juror had their...
Emily, what do you think they mean by ignore the fluff and the drama? The gummies, the empty pill bottle, the rest of it. I think this is the foreperson, but yeah, ignore all the fluff.
We were so pent up with so much information and emotion. And so we decided to just go one by one around the table and just let it out.
In 2020.
And this makes absolute sense to me. They've been there for 15 days without a chance to talk about the case. It makes sense to go around the room and say, what did you think? Where are you at? Let's let everyone say what they need to say. What are you thinking? What are you feeling? Talk to me. Absolutely.
23, Richins published this children's book on grief. She says was to help their
I want to hear what the juror has to say. Oh, the juror's face has a lot to say about the book.
the book in the final days of testimony.
Everyone just felt like they're hit with a truck. We're like, what? Like, what the hell is this?
Uh-huh. That does not surprise me. What the hell is this? Right. What is this book?
It was so odd and so strange. People were really sad because they did not want to find her guilty. They were really hoping that she was innocent.
That makes a lot of sense to me when the jurors like, we went in there wanting to believe that this was all a big mistake. That makes so much sense to me because believing that someone would do what Kouri Richins is convicted of doing pulls back a curtain onto something incredibly dark, incredibly chilling, and incredibly scary. That the person that you could be sleeping next to at night could be planning to do this for months and months and months. And so it also says to me that the jurors went in there with not just the presumption of innocence, but actually the hope of innocence, which is more than a lot of jurors go in with. A lot of jurors go in with like, yeah, I know they haven't proved it. Yeah, they're presumed innocent, but like, why are you sitting over there? These jurors went in with, I really do not want what the prosecution's saying to be true. That is kind of above and beyond just the presumption of innocence. And I think that that is incredibly fair and very, very human. And I appreciate that the jurors shared that they went in hoping that this wasn't true.
We couldn't come to that conclusion. And it was really heartbreaking, this devastating reality that this family was torn apart. And these poor kids will really basically never have a dad or mom.
That's what you would want from a jury. What you would want from a jury is we do not want this to be true. We do not want this to be the circumstance. And there is no other option. Whenever jurors speak out, there will always be a conversation around, is this going to cause a problem? Is this going to cause a problem on appeal? And I don't think that's what's going to happen here. It's actually somewhat refreshing to hear a juror say, this was heavy, this was sad, this was a decision we didn't want to have to make. Juror speaks after delivering guilty verdict in Kouri Richins' murder trial. I love this headline. Look at that. Just the facts, sticking to the facts. We love the facts. Let's see, this is from Park City, Utah, ABC4 from this very morning at 9:42 Mountain Time. Exclusive interview. One of the jurors, identified as Laura, spoke exclusively with Good Morning America, where she talked about what it was like to sit in the Summit County courtroom as the prosecution and defense made their cases. Well, on day one of trial, Laura recalled feeling as if the Richins family was very tight-knit and that Kouri was trapped. That's interesting. There was so much anger towards Kouri from the family, which Laura said impacted her original opinions. Oh, did she change her mind? Interesting. Quote, the first thing we hear is these terrible things about her from her sister-in-law and her father-in-law, and she's just sitting there like all by herself, Laura said. At first I was thinking, without hearing the whole story, that Kouri was definitely feeling trapped. Interesting. I love a juror that's open to changing their mind. And you know what? I was surprised that the defense, because we know the defense watched the Karen Reed trial based on some of the things they argued and did. I'm surprised they didn't leverage the outsider angle more. The juror goes on to say, Laura told Good Morning America that once the rest of the evidence, especially the forensic evidence, was revealed, her opinion was changed, or her opinion changed. She said she was blown out of the water. The jurors could then focus on the facts rather than just the family drama. Well, wait until you see the unsealed walk the dog letter, girl, because damn. One of the most impactful pieces of evidence, according to Laura, was the cell phone pings presented by the state during the alleged drug purchases. They're not alleged anymore, ABC, during the drug purchases. While Carmen Lauber and Robert Cogier's testimonies weren't highly reliable, Laura said the jurors could still grasp what was happening and connect it to the movement of people's cars through their cell phone use. Digital evidence always matters. In fact, Mr. Digital Evidence Kostradimas sent me a message and talked about how great this community was and that he appreciated seeing our coverage of the case and how much we enjoyed the digital evidence. So Mr. Kostradimas, hello. It was lovely to see your message. And yes, the Law Nerds are the best chat on the internet. It was great exhibits and they made it so easy. Kostradimas made it really easy to follow. It goes on to say that Laura noted that some pieces of evidence carried more weight than others. For example, she said that to some, the walk the dog letter was the smoking gun, but to others, it lacked significance. That's interesting. There were jurors that were like, meh, on the walk the dog letter? Quote, it was so amazing to see the difference of opinions people had and perspective, and that happened often with respect to the different pieces of evidence and the witnesses. But we all led to the same conclusion, that she was guilty. It was really heartbreaking. It goes on to say when it was time to decide on a verdict, Laura told GMA that the jurors chose not to take a formal vote, but instead held a roundtable to discuss all the evidence and testimonies. We decided to just go one by one around the table and just let it out, like nothing in particular, whatever you wanted to say, whether it was emotional experience, whether it was about evidence or witnesses or anything, it was just a chance to let out steam, she said. The roundtable helped all the jurors get on track and in the right headspace to make a decision. They needed to process it. During deliberation, Laura shared that the jury discussed Kouri's demeanor. The group had a hard time getting a read on her, stating that she seemed like a statue. Oh no. Well, the defense wanted to make that analogy in closing. Don't blink, ladies and gentlemen of the jury, don't blink. She was very still on the face. You know, a couple of times I would see her laughing a teeny little bit or smiling when she was talking to her defense counsel. But other than that, there was very little emotion. Oh, y'all were locked in on the witnesses when she was facing at them then. Y'all were locked in on the witnesses when she was sitting over there going, what? The most emotion Laura ever observed from Kouri was when the guilty verdict was read. She seemed upset and shocked, but Laura did not feel like she had any remorse. The judge said, if you have an emotional response, put your head down. I think Kouri felt like she was being told she was supposed to put her head down because she didn't clock much of an emotion and she put her head down. The foreperson did not feel like Kouri had any remorse. I think when the verdict was read, I think she was surprised. Oh, I definitely think she was surprised. And she was shocked and upset. I didn't see any remorse whatsoever. Yeah, I agree. I agree, juror. Laura goes on to say, you know, maybe the other jurors had a different perception. I think she was kind of in her little world. That's a kind way to say it. Goes on to say after the verdict was read, the jury was able to talk to the judge afterwards. Oh, y'all got to talk face to face to Judge M. Why isn't that the entirety of the interview? ABC, you are not delivering what the people want to hear. After the verdict was read, the jury was able to talk to the judge afterwards. He told the group that cases such as Kouri Richins can be hard emotionally and not to ignore those feelings. Of course he did, because Judge M is amazing. So Judge M acknowledged that cases such as this one can be hard emotionally and not to ignore those feelings. They were encouraged to talk to people about it rather than holding it in. Thank you, Judge M. Thank you for reminding the jurors that it's hard. Thank you for reminding the jurors not to ignore those emotions and that they're allowed to grieve too. I think that the jurors had a difficult job. I really appreciate seeing that they took it seriously. I appreciate that they shared their perspective on this. They don't have to. It opens them up to the internet. I have not always seen the internet be kind to jurors, and it is such an important thing to hear feedback on how the process is working. And it's nice to hear that for this foreperson, this is working as intended. Law Nerd, a quick thank you to our sponsor, Gusto, who not only makes Team Baker's life easier because it makes payroll easier, but we're actually celebrating our 1-year anniversary with Gusto as our payroll software. Not only does it make it easy no matter where in the US Team Baker is, but it also has saved us a lot of money because it takes care of not just those payroll tasks, but payroll, HR, and more. Gusto is an online payroll and benefits software built for small businesses. It's all-in-one, remote-friendly, and incredibly easy to use, so you can pay, hire, onboard, and support your team from anywhere. Gusto includes automatic tax filing and simple direct deposits. You can manage health benefits and commuter benefits and workers' comp and 401k, so Gusto can grow with your business. Plus, if you need more help, Gusto has HR professionals available when you need it. So no wonder it's the #1 payroll software according to G2 for fall 2025 and trusted by over 400,000 small businesses, including Baker Media. So try Gusto today at gusto.com/EDB and get 3 months free when you run your first payroll. That's 3 months of free payroll at gusto.com/EDB. Just one more time, gusto.com/EDB. Now let's get back to the case briefs. Let's correct the record. A lot of you have seen headlines that the court appointed lawyers for Kouri Richins' mom. That's not specifically true. It is an inaccurate reading of the docket. Way back in the pretrial of this case, the defense asked for attorneys to be appointed for several witnesses, including Robert Crozier. Those things were under seal. The court did appoint lawyers for some witnesses and potential witnesses that were requested at that time, including Robert Crozier. One of the requests was that counsel get appointed for Kouri Richins' mother. There was a docket item that popped up at the end of trial that is a docketed item that seems to correspond with other items that were under seal. But here is what the docket said. This was the proposed order. When lawyers file things and ask for something, they will file a proposed order that says, order doing X. It's kind of like if somebody asks you to write them a recommendation letter and you're like, hey, can you send me an outline? It would really help me out if you could of course, everything I say and it's going to be true, but if you could just send me an outline of what you need, I can help modify it with my own language. Same thing. This is a not signed proposed order that was filed during pretrial and then popped up on the public docket, probably because it didn't get its own docket number earlier on. It reads like an order because it was filed with the defense's request that this happened. Lisa Darden had needed to testify as a witness. We might have seen her get appointed an attorney. However, Lisa Darden probably already has an attorney because Lisa Darden is named in some of the civil suits and her name has come up a lot in the other criminal financial fraud case. Lisa probably already has a lawyer, because she got pulled right into the civil suits because money went to her that the estate's trying to get back. So she probably already has one.
Dear Judge Mrazek, I'm here today to represent my brother, Eric Eugene Richins, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never.
Oh, Kouri is just chewing on her face. It's not going to hold the words in, ma'am. But it's interesting after reading the Walk the Dog letter. Remember, this is June 2023. Walk the Dog was written in September 2023. This is before Kouri's like, bring me home, let's get those bitches. Oh boy.
Or hug him again and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richins legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from four-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. He built a very successful masonry business from the ground up and helped many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events. I wonder when he realized he was in mortal danger. Why did Eric lose his life? Why did the boys lose their father? Was it because of Kouri's greed and desire to get life insurance? And
this guy's like, no, just use the Kleenex and maybe they won't be able to tell. Just use the Kleenex.
Other assets? If so, that is abhorrent. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. We have watched as Kouri has paraded around portraying herself as a grieving widow and victim while trying to profit from the death of my brother.
Oh boy.
Kouri told us she could not help us get anything ready for the funeral as she was too distraught with grief.
Oh boy.
We shortly found out that was not true at all. In fact, she pulled herself off to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe,
she was busy,
and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death.
Holy shit. And we saw Katie say that day, Kouri was talking about who was going to run Eric's part of the business. So somehow Kouri believed that she was going to get half of C&E. So no, she didn't think she was better off with Eric making money. She thought she was going to be the other half of the business partner, pay someone less money to go do some of the physical work. She was going to run the business and take half of that business without the roadblock that was Eric determining how she was going to spend the money. She thought she was getting 50% of the business year over year over year without anyone telling her what to do based on what Katie said. But that's exactly why your partnership should have a buy-sell agreement so you don't end up running a business with someone you don't want to be in business with. Kouri didn't know what was in the buy-sell agreement. She knew what was in the prenup. And in the prenup, it indicated that she got Eric's half of the... Of course, she didn't know about the buy-sell agreement. And in the prenup, it indicates that if Eric divorces her, she doesn't get anything from C&E. But if he dies, she gets Eric's interest in C&E. She just didn't know that Eric's interest in C&E was life insurance and not continuing to run the business in perpetuity because she never saw the buy-sell agreement. She only saw the prenup. Right. She thought that she was just going to take half of that business year over year over year over year over year. And she was going to treat it like her own personal ATM without the pish posh of Eric.
Kouri assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning. It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage.
This is the morning after the party, the Bryce Pants party that we saw the video of. Yes, Kouri was charged with the assault. Yes, Kouri pled with regard to the assault. But when the sister says Kouri assaulted me, Kouri was charged with that too.
When I saw a locksmith in Eric's detached garage starting to drill out his gun safe, I asked Kouri multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here.
Please do.
And then told me to get out of her house. It was then that I told her that she could not kick me out of my brother's house. My sister Katie was now the executor of Eric's trust and estate.
The words I would have said.
And just like Eric, she would not want the defendant breaking into his gun safe. Kouri looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way. And because of that, she attacked me. Kouri put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday and told his family, all of us, that we were not allowed to attend. In addition, Kouri has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands.
Is anyone shocked? Is anyone shocked that she was weaponizing the grandkids?
She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust. Money that Eric wanted to go to his 3 children.
Oh, shit.
As if that were not enough, I have been told that Kouri started telling their 3 little boys that none of Eric's family or friends loved them. She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening.
This is
We
appropriate
all
for
want
bail.
nothing more than to be there for those 3 little boys, my nephews. Yet Kouri has made sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. I am truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility,
This
and there
is,
is no telling what she will do
again,
if she is released.
Appropriate for a bail
Judge
hearing.
Mrazek,
Please don't let her
her
out.
fate lies in your hands.
The statements at a bail hearing are different than what you will see at an impact statement after trial. But I think in this case, we are going to see some similarities. And I wouldn't be surprised if Amy made an impact statement and said, I stood here in 2023 and told you, and I now know, and you can never let her out of custody. Because now they've seen the walk the dog letter where she has threatened, both of them threatened Katie's children and more. I would not be surprised if there is more that they know. And so I think we will see more than we saw in this statement and more than we said in trial. And I think we will see it circle back. There were lots of things in that statement regarding bail that I had forgotten. This did not come in at trial. You are probably feeling some kind of way. You are completely valid. But the way you are feeling might make it hard to be more neutral and objective on the evidence. And a lot of what was said, a lot of the fuckery that Kouri was engaged in does not help the jury decide if she committed murder. It helps you decide if she's the fucking worst. And that's when that balance of more probative than prejudicial comes in. And some of this was determined to be more prejudicial than probative. The incident with Kouri attacking Amy over the safe was more prejudicial than probative. I think the judge has been incredibly cautious, sometimes maybe too cautious. I also think it puts a point on the fact that Kouri didn't know about who the executor of the estate was. There was cash in the safe. Kouri believed that the documents regarding the will and the trust were in the safe. Kouri believed there was a lot of stuff in the safe. cash, weapons, the will and trust documents. So some of the things that we have seen here are things that will be appropriate impact statements. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.